depends on why they're on the land. If they're on your property, and the term you should use is a business invitee. And a business invitee is someone there for, and we say, potential economic gain. Benefit of the landowner. Let's just say store. Okay. So, obviously when you're shopping in Safeway, you are a business invitee. You are on the property of Safeway, you're on their land for the potential economic benefit of Safeway Corporation. Okay? So you are considered a business invitee. Why that's important is that triggers a duty to, they have the store, Safeway has a duty to maintain the store, say premises, can be any kind of business, in a safe condition for the customers. And this includes, and that's a big inclusion, including the duty to inspect. And that's where most of the litigation comes in. Okay. So, if you're in a store or somebody's business office or the doctor's office or whatever, you're on their property for their economic gain. They have a duty, you are a business invitee by law, and they have a duty to maintain the premise in a safe condition, including periodic inspections to make sure it stays safe. Well, let's take the classic case. You're going down the aisle in Safeway, and you slip and fall and break your leg on some olive oil that's spilled in aisle 7. Okay? Now, is Safeway liable? Well, one thing to remember is the standard of care in all of these is what a reasonable, prudent store owner should have done. Okay? Because now we're looking at a store. The question is always going to be, how long was the olive oil on the floor? Now, obviously, if your kid's in the cart squirting the olive oil through the floor of the cart as you're pushing it, Safeway really can't be held liable, because a reasonable, prudent store could not have prevented that. So the case is always, how long was it on the floor in these slip and fall cases? And, it's a question of proof. A lot of people say, well, how can you prove that? Well, that's the plaintiff's job, is to find out how long it was on the floor, whether they use cameras or other people in the store, or find out if it was reported 15 minutes earlier and nobody did anything. They have to discover how long it was there. Because the duty of Safeway is not just to maintain the store, but to periodically inspect all of the aisles. And of course the question is going to be, when did you last inspect that aisle? And believe it or not, in those books that all insurance companies and plaintiffs' attorneys have, they have the standards for how fast the store should inspect aisles in a grocery store. And they're not the same for all the aisles. Which aisle, or I should say area, needs to be inspected most frequently? Condiments like salt and pepper? Okay, well, that would be second most, but which one is always the dirtiest floor in any grocery store? Produce! Sounds like produce, okay? Why is produce got to be inspected more frequently than any other area? Well, the stuff falls on the floor, and it all gets sprayed with those little rainforest jingles or something, and stuff spills, people drop it. So produce, maybe if you don't check it every 15 minutes, you could be liable for not using your duty to inspect frequently. And they have a manual that says produce, every so and so minutes. And where things could spill like ketchup or olive oil, maybe every half hour, which would be the least likely. Canned goods, maybe, or toilet paper, I don't know. Take your pick. But some are not likely to cause risks as much as others. So they have standards of care that are established for these businesses. And that's what we use to establish the duty to a business invitee in that kind of business on that aisle. And then, of course, it's a proof of how long it was there and whether they failed to live up to their duty to inspect. But it's, what if you're like, it's pouring rain out and you're downtown and you want to get the bus on 3rd, you're on 4th, and so you cut through Macy's because you don't want to, it's getting hard not to say the Bon Marché after all these years, but cut through Macy's to get out of the rain. You hate Macy's, you don't have any money, you have no intention of shopping there, you wouldn't buy anything no matter what, and you're walking through Macy's and you slip and fall on a puddle there and get hurt. In Macy's, are you a business invitee? And that's where this little word is so important. In every store that's open, if you're in there, you're a potential customer. They spend a lot of time and money on displays so that people go through who never intend to buy a thing, they see something and they might come back, That's why you cannot get from one end of the store to the other without weaving through all the aisles, because they're selling all the time that you go through there, even if you're just cutting through to get out of the rain. So anytime you're in a store that's open, it's no defense that, you weren't there to really buy anything. You're a business invitee in that store, and they have a duty to you, like any other customer, to maintain the premise in a safe condition and to inspect. Obviously, like in the Safeway example, even if it's in an aisle that doesn't require much, but somebody, say, dropped a glass jar of juice and it broke in the aisle and it's reported in aisle 7 canned goods, there's a spill, well then that clock starts as soon as, if it's reported within a minute, they only got so much time to get somebody there, and those are the easier cases to prove if they don't react to keep it safe. Well, Macy's is only liable, just like my example, if the kid squirts the olive oil out the bottom of the cart. Macy's is liable to use the standard of a reasonable, prudent store to keep their aisles clean. And so the test is always going to be, did they act like a reasonable, prudent store in, checking their aisles and cleaning up known messes? And that's their duty. And if it's something that, even with decent inspection and cleaning, they couldn't have prevented, they're not liable. A lot of people think if you slip and fall, they're automatically liable. No, only if they breach their duty. Please leave. Well, and we'll get to the fact that the assumption is if a store is open, it is open to the entire public. Now, everybody knows that a business has a right to refuse service to customers if they give them some reason to cause a problem. They can ask them to leave. And when that happens, this permission up here to be in the store can be taken away and you can end up being a trespasser, as we'll see. But normally the assumption is in a store, everybody has a right to be there during hours that it's open, okay? And they can ask people to leave, but normally we're going to assume everybody's there legitimately, okay? And they have a duty. It's not strict liability. This is negligence law. So they have to have been shown to fail to live up to their duty, in this case, as a reasonable, prudent store. And believe me, there's standards for department stores, for grocery stores, from years of litigation and all that. People know what they should be doing to run those, and they go through management training, and all of those manuals are admissible as setting up the standard and duty of care that they should have done. Now, if they do everything right and someone still gets hurt, then they're not liable, at least on this basis, because they did nothing. And the accidents can happen. So a lot of people think slip and fall, you win automatically. You have to show what the duty was and that they did not live up to their duty. And that's what caused, of course, the other elements are that a failure is the proximate cause of your injury or damages. So those are the 4 elements that we use to prove any and all negligence cases, which is the most common. But to the layperson, they think just proving how the person did something wrong is enough. No, it's not wrong unless you show there was a duty that they should have followed and then it was breached. So we spend a lot of time in litigation proving this duty. So business invitees, they're the best. They get this protection. We also have a second category of people on our property, and that are people that we call in law a licensee. A licensee